Hi and welcome back to Cheeky Crypto, and today guys we are taking a cheeky look at XRP, and it's not over yet. So Chris, this is all about how the judge denied the motion to intervene by XRP holders, how 𝗕𝗘𝗪𝗓 is claiming that it's not over yet, and he plans to file intervention of the Ripple versus SEC law case, and then obviously. Yeah, some fantastic news here about Ripple fighting back against striking off fair notice defense. So we're going to get into all three of these pieces and news and see what's going on. So if you find it useful, informative, hit that like button. We both really do appreciate it. And of course, if you're new to the channel and you're not yet subscribed, do consider subscribing. By subscribing, you'll be kept up to date with all of the news and videos and live streams that we do here at Cheeky Crypto. It's free. You'll be kept informed. So why not? Chris, anything you'd like to add at this point, or should we jump over to the desktop and see what's going on?
Let's just get straight into it, Nick.
Fantastic. So, judge denies the motion to intervene by XRP holders in the Ripple versus SEC lawsuit. So, attorney, 𝗕𝗘𝗪𝗓 did file a motion to intervene in the case of Ripple Labs against the US Securities and Exchange Commission on behalf of over 6,000 XRP investors only the day before yesterday, or more specifically, March the 14th. The motion was now already denied, and the judge pretty much took no time whatsoever to come up with that denial, but denied without prejudice of renewal in a motion that complies with Rule 3A of the court's individual practices of civil cases, so ordered, and that was done on the March 15th. Now, neither 𝗕𝗘𝗪𝗓 nor Crypto Law had commented on Judge 𝗕𝗪𝗓's decision on Twitter at press time. In a tweet yesterday, or this would have been, I think, must have been like the 16th, I think, or something like that. 𝗕𝗘𝗪𝗓 was still, combative, even if he himself admitted that the chances of the application being approved were rather low. I think it's an interesting thing, but it's important to note, however, that the application was denied without prejudice of renewal, which means 𝗕𝗘𝗪𝗓 could resubmit the application if he would so chose to. And this is an interesting piece, so we're all really hopeful. We want to see this happen as XRP investors, and I think it's really important that the SEC hear from the retail investors that they're supposedly protecting. And I think the judge should also be paying attention as to why on earth would XRP investors want to join as third-party defendants with Ripple when the SEC is supposed to be protecting those investors. I think we really have to have a good look at that. What's your thoughts?
I was going to say, it just kind of feels like it's nothing to do with retail investors. There's something far more sinister about this, in my opinion, than it being about protecting retail investors, because surely you're going to want to hear directly from those individuals that, you're kind of, in a way, indirectly saying have been negatively impacted, right? But I don't feel like any XRP investor feels that way. They may feel let down by the SEC more than anything, in my opinion.
No, I totally agree, Chris. I think it's a testament to kind of showing the world really where the XRP investors, loyalties lie. They're not with the SEC. The SEC did not act in the best interest of the retail investor in this case. So yeah, interesting stuff. But this isn't where it ends, because this cropped up as well. It's not over yet. Attorney 𝗕𝗘𝗪𝗓 will file intervention of a Ripple versus SEC case again. After Judge 𝗕𝗪𝗓 denied, 𝗕𝗘𝗪𝗓's motion to intervene the other day without prejudice of renewal in a motion that complies, all that kind of good stuff that we just spoke about. There has also been some doubt as to what will happen next with respects to 𝗕𝗘𝗪𝗓's efforts on behalf of the XRP community. So to clarify what happened, 𝗕𝗘𝗪𝗓 now spoke out in an interview with the On the Chain YouTube channel. In addition, Jeremy Hogan also stepped forward to calm the heated discussion about whether all is lost. And Hogan tweeted that Attorney Deaton's motion to intervene is not DOA. The judge basically said he has to submit a letter first telling her what he is going to file before he files it. It's a local rule and honestly not very common. The motion can and will still be filed. So really interesting stuff, and clearly it's a local rule and not a common one apparently. So maybe just didn't follow the protocol there. But so yeah, if he does that, fine, fantastic. So for his part, Johnny Deaton sharply criticised a 𝗕𝗘𝗪𝗧𝗧 article for claiming that there is a deadline to file the motion to intervene, and this is what they say there. So where they're saying that the SEC won an extension to respond to my motion to intervene, as I pointed out, why would you need an extension when something has already been dismissed? There's nothing to reply to. She dismissed it without prejudice. So in that article, they're saying that if we don't get this extension, then XRP holders will be denied a seat at the table forever. And it's the most ridiculous thing I've ever heard. So at least they're calling out the... I don't want to go... Some of these articles, they do feel that they're written by people in high school or something. It doesn't quite feel right sometimes. But good that someone's calling them out on it at last, which is good. So as Deaton further explained, the intervention can be filed even years after the lawsuit is filed, right? So in that respect, is no deadline. Further, Deaton also laid out from a legal perspective why his motion was denied. According to court's local rules, a pre-motion letter must be filed. And clearly that wasn't done. And Deaton wanted to calm, or claim an exception because further delays could result in a loss of rights. However, the judge denied to do so. So Deaton will now file the pre-motion letter. It will be refiled, as Deaton clarified. As to what will follow, the attorney explained. When it gets refiled and she rules, I believe we will meet all four factors of intervention. If she agrees and allows us to have a seat at the table, then what we do is file basically a motion for summary judgment, a declaratory judgment where I will go around asking people how XRP is used and overwhelm the court how this asset is out there in the world, independent of Ripple, and there's no basis in law that the EU can SEC that is a security. I'm not sure what they quite mean by that, but basically, yeah, there's no way that it's a security. We know that. The rest of the world kind of knows that. Just the SEC that are kind of ignoring that point. But so fantastic things going on there. We'll pay close attention to what happens with all of that. And then there's also this, right? So Ripple fights back against striking off fair notice defense. The legal battle between the SEC and Ripple continues to provide news and updates on a daily basis, right, Chris? Because we've covered quite a bit recently, right?
Yeah, we have.
And it's not that I don't mind it. I don't mind it at all. But if you guys are getting bored of the XRP stuff, let us know. There's an abundance of stuff going on here with XRP. And as reported, the SEC filed a letter, seeking to have one of Ripple's key defenses declared legally improper. And I think a lot of people will remember that, what's going on there. But the SEC's anticipated motion to strike is meritless. The striking of affirmative defense is disfavored in this circuit, and the SEC cannot remotely meet the high burden of showing that there is no question of fact or law that might allow the defense to succeed. First, Ripple's lack of fair notice defense more than satisfies the liable or liberal pleading standard, and thus cannot be struck. Second, Ripple's fair notice defense requires factual inquiry and context, which is why courts address this defense on the merits with the benefit of a developed factual record. So really important. And Ripple's legal team argues that the SEC's tellingly does not cite a single case in which a court rejected the fair notice defense at the outset of litigation. Now, and Ripple is likewise unaware of any such authority. Instead, the SEC attempted to sidestep the issue, or this particular issue, by relabeling Ripple's defense as, equitable, and or void for, vagueness of defense and all that kind of stuff. But Ripple has not asserted those defenses, and the SEC's attempt to change the subject and create a straw person should be rejected out of hand. Third, Ripples argues that even if the fair notice defense involved a purely legal question, which it does not, the Second Circuit has cautioned at that disputed and subsequent legal issues should not be decided on a motion to strike without the benefit of a developed record. So just the day before yesterday, Ripple accused the SEC of withholding evidence, right? And it's going to get really interesting. This whole thing, Chris, feels like we should just get a bag of popcorn, sit back, enjoy the show, because we all kind of know how it's kind of going to end, right? It's not going to be pretty for the SEC. I can just kind of see that coming to fruition already. They've made so many errors so far, and this thing's only really just started. So sufficient evidence to justify a fair notice. Further, Ripple's brief cites the familiar examples and arguments, as to why Ripple did not receive a fair notice. XRP's unfettering trading over 200 exchanges and statements by regulators in Singapore, Japan, and the United Kingdom that XRP is not a security, the SEC's communication with third parties, statements by senior SEC officials in 2018 that Bitcoin and Ether are not securities, FinCEN's determination in 2015, and SEC's enforcement actions against Kik and Telegram, which engage in conduct that did not resemble that of Ripple. So for these reasons, Ripple argues that the strike of the fair notice is not lawful. The SEC's anticipated motion to strike is fatally flawed at the outset, because Ripple's lack of fair notice defense is well pled. It states a valid defense and sufficiently alleges facts. Nothing more is required. And I like that. And at the end of the letter, Ripple asks the court not to set a joint trial date for Brad and Chris, for the motions to dismiss, and Ripple Labs a fair notice hearing. So should the SEC proceed with filing the meritless motion to strike, Ripple respectfully requests that this court set its default briefing schedule unlinked to the individual defendants' motions to dismiss, as one has no bearing on the other. So really interesting stuff, Chris, that's come out in the last couple of days, wouldn't you say?
Yeah, definitely. But, it still aligns to the tune that we've been playing here at Cheeky Crypto. And that is the fact that the SEC look like they're on the back foot a little bit here. They don't have a strong case. It would look like that, on the face of it.
It really does. And like I said before, it's almost, entertaining at this point to just see how they just approach this whole thing. I mean, it's a bit of a circus act, really, Chris. And I know we get called clowns a lot on this channel by various different people, and actually, I feel that the only clowns at the moment are trying to sue Ripple. But there you go. It is
a bit of a circus, that's for sure.
It is a bit funny, but nonetheless, hopefully you guys found this useful, informative, maybe even entertaining at times. If you did, hit the like button. We both really do appreciate it. And of course, if you're new to the channel and you're not yet subscribed, do go ahead and subscribe. By subscribing, you'll be kept up to date with all of the videos and live streams that we do here at Cheeky Crypto. So with all that said and done, we hope everyone has a fantastic day, and we'll catch you all in the next one.
Yeah, take care.